And we're live. Welcome back, everyone. Attorney Craig Stager here. I think I say this every time. I'm a little late today, but that's just how the practice of law goes sometimes. So if you don't know me, my name's Craig Stager, and I'm an attorney in Wisconsin, but I also practice in Iowa and Minnesota, and I do mostly litigation um, and personal injury. Good to see you too. I hope things are well for you out in California. Um, so I wanted to. So today's topic, I wasn't sure I was going to live stream because I was traveling today, but it led me to talk about something that I think can be very confusing to people, but very helpful to kind of understand this. So, um, so today's topic is talks about workers' compensation and third party fault. Now, if you don't know what third party fault is, that's okay. Let me explain it to you. So, in most states, and let me just talk about Wisconsin for example, workers' compensation is a type of kind of no fault coverage for people who are injured or exposed to some chemical or condition that causes a sickness or illness while at work or in the you know in proximity to work or whatever, right? Every state has a little different set of rules, but the general framework tends to be the same. It's there to provide protection for workers if you get injured at work, regardless of if anyone is at fault. Sometimes things just happen, or sometimes things happen because the worker himself or herself is not paying attention, is not being careful. So if you are at work and you are not paying attention and you trip over a cord on the floor, it's your fault. But if you're at work, it's going to give rise to a workers' compensation claim. So that might cover your medical expenses, lost earnings. Sometimes, if you're injured bad enough, you might get retrained, or if you can't go back to work, lost earnings for the foreseeable future. And that can be true even if the injury is your fault, or let's say a coworker's fault, or even your employer's fault. The big trade-off for that, the big um, trade-off for workers' compensation claims is because it protects you even if there's no one at fault, it also insulates the employer and your coworkers if someone is at fault. And it limits you to whatever the statute says, in terms of, usually it's you are entitled to fewer damages than you would if this was a straight up personal injury case. Let's say you were just a visitor to your place of employment and you tripped and fell over the cord because they didn't you know um, put it under the carpet, or they didn't mark it or whatever. In that case, someone that's just visiting, if it wasn't your own fault, would have a claim against the employer and the business owner and the property owner, probably for damages beyond what workers' compensation provides. So that's sort of the trade-off. Workers' compensation is a kind of no fault coverage for you when you work, but um, the problem is that it restricts and limits your damages even if there is evidence of fault, and sometimes like grievous fault, like reckless type of fault. Now, some states will have penalties if it is a really egregious conduct, but not all states. And I don't personally do workers' compensation. One of my law partners does. Uh, but so what happens? So one of the things that you run into is people in cases where the employer is at fault, did do something wrong. Let's say they took off safety barriers, or they didn't equip their employees with adequate safety harnesses, or didn't train them adequately. Whatever the case may be, there's actual fault on the part of the employer. It doesn't matter. The employer is limited to whatever the statute says the employee is entitled to for workers' compensation benefits. Okay. And because of that, people can be very badly injured at work. And and it be an entirely avoidable injury because the employer was trying to cut corners or whatever. In a lot of situations, the employee is out of luck beyond whatever workers' compensation provides. And like I said, workers' compensation tends to provide fewer total damages than you would get in a personal injury case. The trade-off being, well, it goes to every employee, even if the employee him or herself was at fault. Okay, so that's sort of the basic structure of workers' compensation. And what does that mean? So, what are third party claims? So, third party claims might be, let's say, suppose you're at work and let's say you're at work in the company has a loading dock and you work helping to unload you help work to help unload trucks, right? If you get injured by a forklift operator, a fellow employee, you're going to be limited to workers' compensation. But let's say a truck driver, someone else who is backing up, isn't paying attention and they run into you. If that trucker is employed by someone else, you probably have a claim, just a regular claim against them for personal injury because they're not your employer and they're not your co-employee. So you're not subject to the rules, the exclusive remedy. We call that the exclusive remedy rule, which says if you're injured at work, your exclusive remedy is whatever the workers' compensation statutes. That's what that means, okay? But it doesn't prevent you from bringing claims against other individuals, other companies, as long as they're not your employer. And so, what we're often looking for is um, third-party claims against someone you can actually sue them. So, to answer your question, is it better to sue the employer? You can't actually sue the employer. That's the thing. You can't bring a civil action against a lawsuit in most states as long as workers' compensation applies, right? But you can if there's a third party claim against a contractor or or let's say a product, and I'm going to talk about that in a little bit today because that's what we were looking at. You can sue other people as long as they're not your employer. I'm not familiar with that case. I'll have to look it up. So I'm not familiar with it, so I really couldn't comment about it. So I already mentioned like the example of like a trucker, let's say from another company backs up, and if they hit you at a loading dock, if they were at fault, if you can show negligence, you may have a claim against the truck driver and their employer and their insurance company for your injuries. Okay. Another example is, let's say you're at work and let's say you are a roofer and you are working on a roof and your employer actually does equip you with, let's say, body harnesses and fall safety equipment, right? But let's say that equipment is defective. It doesn't work as intended. It breaks. It's not reliable. Whatever the case may be, if you are injured in at work and the reason for it is because a product or a tool that you were provided fails or doesn't act as designed, you may have a claim against the manufacturer of that product, right? Here's an example. So we had a situation once where a guy, I think he was a carpenter or a contractor, and was working on a ladder, right? That was part of his job, and he fell off this ladder and was injured. But because he was working, he has a workers' compensation claim against his employer. However, there's evidence that the ladder itself that his employer purchased was defective. If it's defective, then in addition to the workers' compensation claim, you can then bring a regular civil claim against the manufacturer, maybe the seller, maybe the retailer of the ladder, if you could show that the ladder was defective. Maybe it doesn't have adequate warnings, whatever the case may be. That's what's called a third party claim. And so the reason why we look for that is typically typically the benefits you can get, the damages you can seek in a personal injury case, so a non-workers compensation claim, is generally better overall for the employee. And so anytime a third party claim exists, we're looking for that and want to pursue that because it increases the value that we can recover for our clients. And so so just today, we traveled about 3 hours away in a matter involving a workplace injury, a very bad workplace injury for one of my partner's clients. And we're looking at, is there claims against the companies that maintain the equipment this person was using, and we're also looking at, was the equipment that he was using defective in the first place, right? I don't know if it was or not, but we're going to look at that and see um, if there's anything there because he has catastrophic injuries. And so those are the kinds of things that you do as attorneys to try to maximize as much as possible what you can recover for your clients. And sometimes that gives rise to third party claims. And then if that happens, usually the workers' compensation has a claim for reimbursement, or we call that subrogation. If let's say the guy that falls off the ladder and he has to go to the hospital and has surgery, workers' compensation might pay those medical bills. But then if you pursue a third party claim against the manufacturer of the ladder and you recover money, at least under Wisconsin, you have to repay workers' compensation a portion of its medical bills. So that's how that works. So that's how the workers' compensation structure works, and how there may be exceptions to it, generally as to other parties, not to the employer, him or herself, although there can be statutory penalties. Let's say if they act like recklessly, or if they fire someone while working, for them, those kinds of things. Sorry, it's been a long day. So, do independent contractors get workers' compensation, or do they sue the parties? So, this could vary by state, but let's just talk about Wisconsin since that's the one I'm most familiar with. Generally speaking, a contractor, a subcontractor, because they're not an employee, is not going to fall under the workers' compensation rules. So that means, number one, they might not be eligible for workers' compensation benefits, but also they're not usually limited to workers' compensation benefits. They can actually bring a lawsuit against whoever hired them or whatever. So, yeah, the independent contractor status can be um, good for the employee if there's evidence of fault, so there's someone they can sue, but can be bad for the worker or employee if, let's say, they caused the accident, they caused their own injuries, because that's where you want workers' compensation, which provides benefits even if the employee, him or herself, is a cause of it. So that's a good question. I hope that answers that. And there may be rules. I mean, sometimes companies and employers try to um, call people independent contractors when they're really not, to try and avoid, let's say, for example, workers' compensation laws, or to trying to get around paying taxes or providing other benefits, um, overtime, unemployment, things like that. So employers will oftentimes try to designate someone as an independent contractor, but more or less treat them as an employee because it's better for the contractor, and sometimes that can backfire. And the employee might be able to argue, actually, you really are an employer. You should have carried workers' compensation coverage, or if you do, this person is covered. And so that kind of litigation does take place. Trying to think what else. Um, just looking here at some of the questions you had. You had a question about COVID. I wonder if anyone filed workers' compensation for COVID. I kind of remember that there was, and but I'm not a workers' comp. I don't do workers' compensation myself. I like for my what I was working on today. My partner has a workers' compensation claim. We went over to talk to some witnesses to see if there is a third party claim. So my role tends to be more on the lawsuit side of things, not on the workers' compensation. But I do believe that there was, I think there was evidence that employees were receiving workers' compensation benefits for getting COVID. I think maybe one of the challenges would be showing that you got COVID at work. It was really hard back in the day to really determine where people got COVID because it was so contagious. So I think that was perhaps a problem. And it may have been that the governors or whatever in their like declaring an emergency may have exempted employers from the workers' compensation um, obligations for COVID. Oh, um, so I believe is correct, but I really don't know the answer to that. And there are going to be some companies, some types of employers that are exempt from workers' compensation. The one that I think of the most, I believe, is like here in Wisconsin, we have a lot of farming. I I believe there may be exceptions for workers' compensation for certain types of farming and agricultural jobs. I think that's for a couple of reasons. Number one, those are just inherently dangerous activities anyway, and it might be really expensive and cost prohibitive to even get workers' compensation coverage. And also, I think there's just oftentimes legislation, especially in agricultural states. There's rules to try and encourage farming, especially small scale farming. But sometimes I think there may be rules that only require workers' compensation if you have a certain number of employees. I'm just not personally familiar with those rules. So yeah, I mean that was part of the thought process, I believe, for workers' compensation is to prevent employees from suing their employer every time they got injured at work. So I think it was designed to cut down on lawsuits and, in fact, makes it illegal basically to bring a lawsuit against your employer if it's a workers' comp type injury. In California, it's I hear it's based on under over 50 employees that can claim denying work comp for smaller businesses. That I don't know. Well, I don't know anything about California. Um, I know that there are employee thresholds for certain types of benefits. I believe family and medical leave, like the requirement to provide unpaid leave to people that have medical leave or medical issues come up, may I believe there are some of those rules only apply to employers that have at least 50 employees. I don't know if there's a similar thing for workers' comp in some states. I'm just not sure about that. It could be. Wouldn't surprise me. Anything else? I had a pregnant employee that threatened to sue California Department. um, yeah, that's 10. Well, I don't know about California. That sounds like a family and medical leave issue, which, there's a federal Family and Medical Leave Act, which I believe requires, is it 6 weeks or 12 weeks of unpaid leave? So unpaid leave. And then think a lot of states have their own family and medical leave law, so Wisconsin has its own structure that I believe provides some greater benefits to employees. Usually, if the federal government has a statute and then provides benefits, and then if the state system requires fewer benefits, the whichever one provides more benefits tends to trump the other one. That tends to be the one that the courts will apply. At least that's my understanding. Yeah, so you get 12 weeks under federal and 8. Yeah, I believe it's been a while since I've dealt with family medical leave, but I believe it is. Um, I think maybe it's 6 weeks in Wisconsin. I'm not sure, but um, so I think in a lot of time, like if you have a state that has, I mean, generally speaking, the Federal Family Medical Leave Act I think is going to be the most generous, but I'm not an expert on that, so I shouldn't say. Yeah, I mean, I've been doing this long enough. I used to do discrimination cases, employment discrimination, overtime, harassment. Wisconsin's a little unique in that unique in that we maybe there's more states have adopted it, but we have a statute that prohibits discrimination based on criminal conviction, which is certainly unique. So in most states, and I believe under the federal rules, there's no like an employer can discriminate against you if you have a crime on your record, as long as the charge of the crime, the criminal charge doesn't reasonably relate to the job. For example, if someone has a theft conviction on their record, um, an employ, a bank, for example, may have a good argument that that prior conviction reasonably relates to the job they're asking to do, and we should be able to screen out and not hire people that have theft in their background. On the other hand, what happens in Wisconsin a lot of times is someone might, let's say, gets a DWI or a first offense drug possession type charge or something like that. It's a crime, but there's going to be a lot of jobs where that isn't going to have anything to do with their ability to do their job well. You know, a factory worker probably, even if they have a DUI, as long as they don't have to drive as part of their job, it doesn't reasonably relate. And so an employer couldn't refuse to hire, couldn't terminate an employee at a let's say a factory for a DUI. But as I said, a bank might be able to discriminate against someone that has theft or perjury or something like that in their background. Yeah, back in the day when I did these kinds of cases, there was a national employer, a company that I won't mention the name, but they had a nationwide policy of not hiring anyone who had any drug. They had a zero tolerance policy for anyone with a drug record, even if it was just, let's say, one charge of possessing a small amount of marijuana. This employer had a national policy. We're just not going to hire those people. Well, they ran into problems because if they had their business in Wisconsin and they refused to hire someone because of that, what I can tell you is that had nothing to do with the type of work that they were doing. And I would regularly get these people in. I'd ask who the employer is. I'm like, yep, okay, they violated the law. Let's go do it. I'd be dealing with the same lawyer, and they'd be like, yep, and it took a while. They eventually caught up. They adjusted their policies, their hiring policies, to account for this. But um, there was a bunch of problems they had in Wisconsin until I think their legal department figured out that we can't just do that in Wisconsin. Yeah, and I think in Wisconsin, there is a difference between there's a different standard between a conviction and being charged or arrested. I don't remember what it is actually off the top of my head, which one is more lenient, but there's a different standard if let's say an employee has just been arrested but hasn't been convicted versus someone who actually has been convicted and has a sentence on their hand. That I believe that the standard is a little bit different, but I don't remember what it is. Are you talking about for like doctors and healthcare providers? What- I assume that so yeah. So I haven't really dealt with employment law situation for doctors and healthcare providers, but I have run into this database in medical malpractice cases, and I really don't want to get into a lengthy discussion about medical malpractice, other than to say hospitals and clinics, whatever, regularly use the database as an argument for why they can't settle medical malpractice cases because if they pay anything, even if it's nuisance value, so to speak, they have to report it to this national database, and that can interfere with their ability to get a job somewhere else if they want to. I think the practitioners database was originally designed with a good intention in mind to protect the public from, let's say, bad doctors who have a lot of claims. But I don't know how much it actually helped with that, but it has had the side effect of really stifling settlement of medical malpractice cases, which has not really been good for both the patients as well as the physicians themselves. So that has become a real problem in this country when it comes to medical malpractice. I suppose so. I'm not familiar with it. I have tended to think that it's sort of um, what do I say, overly emphasized by insurance companies and doctors to try and justify why they don't try to settle medical malpractice cases. But maybe there is some real concern there. With it, what that means is they just say, well, we can whether we pay you $1 in settlement or whether we go to trial and lose and owe you $1 million from our standpoint, it all looks the same because we have to report it to this database, and they don't want to do that because there's a good chance that they win at trial, in which case they don't have to report it. Yeah, so that's a real. I think that is a real problem. Um, because what I can tell you from the medical malpractice side of things is it very much uh, really interferes with the ability of medical malpractice cases to be treated like other cases, which means that we approach it from a practical economic standpoint, and you know cases just don't settle. They don't settle because the doctors and hospitals just don't offer anything. It's always zero because they say we'll have to report that, and so that's the excuse you've entered. Maybe it's justifiable. I don't know. And see, yeah, and see that's just it. If they settle the case for $1 just to make it go away, they have to report it, even if the underlying claim had no merit whatsoever. But if they go to trial and they win, they don't have to report it, and the statistics are such that the hospitals, insurance companies win the vast majority of trials for medical malpractice. So they're like, well, why the heck? Well, let's just roll the dice. We At least we have the chance of not having to report it, but if we settle it, we have to report it anyway, right? And that's what. So it can be a real barrier. I don't think it really accomplishes what it was intended to do, and it has had the I would say maybe not unexpected. Maybe they knew this when they implemented, but it's had the unintended consequence of really making settlement almost impossible in medical malpractice cases, unless it's just super obvious and super egregious. Yeah, I always tell people with medical malpractice cases that the first dollar that you get on the table in medical malpractice cases is the most difficult. The first dollar. Once you get them to offer the first dollar, then it's just dollars and cents after that. Then it's just a matter of what's this worth to you? Because if you're gonna have to report it anyway, whether you report $1 or $1 million, it's already going to get reported. Yeah, I don't know how that works. We don't really have sealed cases for medical malpractice in Wisconsin. Maybe criminal stuff, but I haven't done criminal cases in years. So license it gets reported more so than the dollar. All right, I think as I understand it, what I've been told is maybe I don't know what I'm talking about, but the, the problem that is that when I have had these cases and I still do them, I'm always told it doesn't matter the dollar amount, we still got to report it anyway. That's why we can't offer you nuisance value to try and settle your medical malpractice case. That's at least that's what the defense attorneys always tell me. Whether they're telling you the truth or not, I don't know. Yeah, I mean, it was it's common for cases that settle that will be done confidentially. The last medical malpractice case I settled was done. There was a very strict confidentiality provision, which means that I can't really talk about any details of the case, can't say how much it was, whatever. It was my client had to sign an agreement promising to keep that settlement a secret. Um, but I don't think that stops them from having to report it. I'm sure they did have to report it. Anything else? Anything else about workers' comp or anything like that? Hmm. Sorry, I'm yawning today. Just been tired. I suppose that. Well, yeah. I mean, I think the reason why they want them sealed typically is so that the lawyers can't tell other lawyers. Oh, by the way, I sued this hospital and this doctor, and I got them to pay X number of dollars. They obviously don't want any of us to get the idea that they're willing to pay money. They really do a very effective job of stifling any type of collaboration by attorneys and things like that. Okay. I think from what I've heard, and I don't know if this is entirely true, I think that how often cases settle and whether they're done under seal is varies a lot by state. I think in some states, maybe California, maybe New York, I think it is more common for medical malpractice cases to settle and there be sort of a confidentiality or a sealing of that. My experience in Wisconsin, at least, is that settlements are very rare, and so then these confidential things are also very rare. And when you say you have lots in California, is that medical malpractice claims? Is that like because you know criminal cases, or is it licensure disputes? Because like here in Wisconsin, I believe it's the Department of Regulation, Licensing and Regulation. I'm not entirely sure that that's the correct name. But, to practice medicine in the state of Wisconsin, a doctor has to get permission to do so. So they get a license from the state, and the state can initiate um, disciplinary provisions against the doctor that may or may not relate to an issue that's in a lawsuit. But if there's evidence of neglectful care or whatever, the the state, whoever regulates it, can actually go in and discipline the doctor. Maybe take away their license for a period of time. Maybe just give them a private reprimand or a public record reprimand. There's lots of things available, which is an entirely different structure for the most part than, let's say, medical malpractice. Yeah, I think that is probably true. Um, I have found that confidentiality agreements are becoming more and more common over time than they were when I first started practicing almost 20 years ago. But it can and does seem to depend on the nature of the case and the value of the case, and how likely it is that something is going to lead to additional litigation. So if someone, let's say someone sues a car manufacturer and claims that their brake system is defective, right? And let's say the car company settles that case. That company is probably much more careful about having that settlement made confidential because they know they've got thousands or millions of these cars out on the road, as opposed to, let's say, someone slips on an icy sidewalk on my property and gets hurt. In that case, they probably don't care as much because that's kind of a one-off thing. So I think that's a big factor in terms of whether the defendant or the insurance company wants a confidentiality provision. Okay, so I'm gonna have to wrap this one up. I apologize. I'm gonna try and get over to the gym and work out a little bit before I head home. So it was good seeing you. I will probably be back tomorrow, maybe. Otherwise, I'll try and live stream later this week. If anyone has any questions or thoughts on topics they'd like to have, feel free to leave a comment, or you should be able to go down to the description. You can call or you can text me an idea or a question you have. I'm happy to try and address those topics. If you have a particular legal question, like something happened to you or a loved one and you think you might need a lawyer, don't leave that in the comments section. Go ahead and talk to a lawyer directly. Feel free to reach out to me if your issue involves Wisconsin, Minnesota, or Iowa. Otherwise, try and find a lawyer in the state practices where you're at so they can answer that question. Yes, you're welcome, and thank you for always showing up in my comments. It's a nice to have you there, and we'll see you next time. So thanks everyone for watching, and until next time, everyone, have a good one.